What really happens when DIY wills land in probate court? Today, I sit down with Judge Andra Hedrick, the first female probate court judge in Davidson County, Tennessee, to talk about what she sees every day from the bench. We'll explore the rise of DIY wills, internet forms, and quick fix estate plans, and the confusion, cost, and family conflict they leave behind. Judge Hedrick pulls back the curtain on the probate court process and shares what people should know before deciding to go it alone. Welcome to the Death Readiness Podcast. This is not your dad's estate planning podcast. I'm Jill Mastriani, former estate attorney, current realist, and your guide through wills, trusts, probate, and the conversations no one wants to have. If your Google search history includes, "Do I need a trust?" What exactly is probate? And am I supposed to do something with mom's will? You're in the right place. A few years ago, on the Wednesday before Thanksgiving, I had a really important hearing in probate court before Judge Hedrick. Like a lot of working moms, I had more than one thing on my mind that day. My daughter April was in 6th grade and had the day off from school for the long holiday weekend. I asked Judge Hedrick if April could sit in and observe the probate court proceedings. Her reply, how would she like to be a junior court officer for the day? April loved that idea. She loved it so much that she told Judge Hedrick's mother, who happened to live just 2 doors down from us. Judge Hedrick's mom and April were good friends and even co-hosted our neighborhood's annual ice cream social with their homemade ice cream. Judge Hedrick's mother asked if I could give her a ride to court too. Judge Hedrick was newly elected to the bench, and her mother had not yet seen her in action. So there I was, on the Wednesday before Thanksgiving, standing in probate court with April serving as junior court officer and Judge Hedrick's mom in the audience, probating my first holographic codicil. A codicil is an amendment to a will, and the term holographic means that it was in my client's handwriting. Although my client had invested in a properly drafted will, when it came time for revisions, he went the DIY route, scribbling a few notes to capture what he wanted to change. My job was to convince the court that those handwritten notes were a valid amendment to his will. I had 2 witnesses ready to testify as to my client's handwriting. April solemnly carried the original document, the holographic codicil, up to Judge Hedrick. And that day, with April's help, I probated my very first holographic codicil. After court, I took April and Judge Hedrick's mom out for lunch. To this day, April still holds the title of my favorite junior court officer. If you're worried that your parent is going to try and go it alone with a DIY will, check out my parent prep plan. It's for adult children who know their parents need to get their estate plan done, but just can't get them to start. In the parent prep plan, I help find a state-specific attorney who's the right fit, and then I walk with your parents through the process, organizing assets, prepping for, and even attending attorney meetings, and following up afterward to explain things in plain English. I also keep the plan moving forward when life gets busy, so you don't have to be the one chasing documents or trying to translate legal jargon at the dinner table. You'll find the link in the show notes and at deathreadiness.com/parentprepplan. Now let's turn to my conversation with Judge Hedrick. Hi, Judge Hedrick. Thank you so much for being here today.
Hey, Jill. Good to be here.
We have not had a probate court judge on the podcast before, and probate is a term that not everyone knows. I think a lot of us are afraid of probate, and we're told that we need to avoid it. But can you tell us what exactly is probate?
Sure. So the word probate can be used as a noun, as a verb, or as an adjective. And people, including lawyers and non-lawyers, kind of use the word loosely. If we're talking about probate as a noun, it's a thing.
Okay.
Right? And, like my court is a probate court. If you're using the word as a verb, saying, well, I probated the will, or I probated the estate. Literally, the word probate translates to prove. So someone who probates a will is, in effect, proving that the requirements to follow the will have been met. So proving the contents of the will.
So if somebody has died and left a will, is it not really a valid will that can be acted upon unless the probate court says that it's valid?
So when people do a will, they're signing a piece of paper that they hope and assume will meet the requirements for probate someday. But the will doesn't actually have legal effect until it's what's called admitted to probate, which means that a judge or an authorized special master or some sort of judicial officer has looked at it, checked to make sure it has whatever that state requires for witnessing and notarizing and so forth. And if a judge or a judicial officer says that it meets those standards, then it can be admitted to probate and actually have a legal effect on how somebody's property passes.
When you say admitted to probate, what does that actually look like? So if someone is in your courtroom with a will that they're trying to get admitted to probate, what is the process and what happens when a will is officially admitted? Does the person who's administering it get any sort of proof from your court that the will is valid?
So typically the proof comes by way of a sworn petition. And when I say sworn, that means, the person who signed it did so in front of a notary public, and it stated that all of the information in the petition is truthful. And so the process of probate starts when a sworn petition is filed that has a lot of information in it.
And who might file a sworn petition?
Usually it's a lawyer who is assisting a family member of the deceased person in bringing the will forward for probate. Now, sometimes wills are offered for probate by people who aren't lawyers, and they have to try to prepare their own petition.
Is that called something different when someone who's not a lawyer comes to court and offers a will for probate?
That's called pro se.
Okay.
So when a person represents themselves and does not have a lawyer, that's a pro se litigant. And, interestingly, a pro se litigant is still held to the same standards and legal requirements as lawyers. So they sometimes struggle a little bit to try to figure out what those standards are and meet them. So, we might have a case brought by a lawyer that it comes to court and it gets approved on the first try.
Right.
Sometimes when a non-lawyer comes in to do the very same thing and they didn't exactly know how to do it right, it might take 2 or 3 tries before we're able to finally approve what they're asking for.
So if a lawyer or a pro se petitioner comes to court, the petition to probate the will is filed ahead of time. And then you're reviewing it with the will. And what does that look like in the courtroom? What are the processes or conversations that are happening?
Well, interestingly enough, sometimes we don't even have to have a conversation in the courtroom. Under certain types of situations that are very clean and neat and not controversial, the paperwork is filed and the judge looks at it and examines the will itself ahead of time and may decide that a hearing is not even needed because there are no questions unanswered.
Oh, wonderful. And then how would the petitioner be notified? Well, this looks good. You don't even have to come to court.
Well, in our county, and that's not true of every court, but in our county, we have an e-file system where the person who files the petition does it online through an e-file account. And if an order is signed approving the petition ahead of the hearing, they get an e-file notification that lets them know an order has been signed. And then they can pull a copy of the order and look at it and see that they don't have to come to court.
Okay, great. So that's talking about decedent's estates, but does probate court handle anything other than wills?
We do. We actually have a broad list of different things we do. I would say that the most common thing we do is handling estates of persons who are deceased. That is the most common thing. But we also handle related guardianships for minor beneficiaries. So think about the scenario where a person dies, they have a minor child, 7 years old, that's going to get a share of the estate. You can't write a check to a 7-year-old.
Right.
So there's a separate legal proceeding that's required for the minor, the person under 18, in order for their inheritance to be overseen by a guardian. and monitored by the court to make sure that the money's handled properly. So guardianships would be one example similar to that.
So is it not just the minor's surviving parent, if there is one, that just gets to handle the money?
No. In fact, when you have a child or adopt a child, you obviously have parental rights to do certain things like take them to the doctor, enroll them in school, sign a permission slip to, do something with school. But that actually doesn't give you any rights whatsoever over their property. And when we're talking about inheritance, that's property. So just because you're the parent doesn't give you the right to receive their inheritance for them. You have to go through the courts and legally be appointed and have your activity monitored to make sure that the children's money is not misspent.
So the surviving parent might be appointed as the guardian after a court guardianship proceeding, but it's not as if that would happen automatically if there's a minor who's entitled to money or any kind of property.
That's exactly right. It's not automatic, although that is the most common outcome, is that the surviving parent is the one that gets appointed. But, appreciate that a lot of folks are divorced. So can you imagine if one parent dies, leaving money to their child, and maybe the deceased parent's family doesn't have a great relationship with the other parent? That's when sometimes you see conflict in terms of who wants to be in charge of protecting the kid's money. But usually it is the surviving parent that ultimately gets appointed.
You are in Nashville, which is Davidson County, Tennessee. What happens if there's a young music star, say Taylor Swift? And I believe she might have come through the court at some point because she was earning money as a minor. What would someone like a young Taylor Swift need to do in Nashville if she's going to be earning money?
Sure. So the thing about being a minor is the default rule is that you cannot enter into a contract and be bound by that contract.
Right.
So let's say I'm a 16-year-old singer-songwriter and I have all the talent in the world, and an agent and a record company wants to do a deal with me. They know that as a 16-year-old, I'm not bound to that deal unless there is a court who has blessed the transaction. So while they're not terribly frequent, we do from time to time in probate court get minors that come to us with their moms and dads, and usually a lawyer or two and a record company and some others involved in the mix. And what they do is ask to be what's called emancipated.
Okay.
And emancipation is not, saying that they're disowned.
Right.
By any means. It doesn't mean they don't have to take out the trash anymore, make their bed, or, listen to their parents. But what it means is the court is giving permission for them to enter into a contract, even though they're not 18 years old yet. And crucially, to be bound by the terms of that contract once they turn 18.
So that's emancipation.
Mm-hmm. These are highly scrutinized deals that have lots of lawyers and judges involved looking at them to make sure that they're fair and appropriate for the minor. Because otherwise, the persons that want to contract with them are not going to expend the time and money and energy into developing this young person unless they know they have some ability to stay in the deal after the child is 18.
And then you have conservatorship proceedings also, which in Tennessee is where somebody is getting authority to act on behalf of an incapacitated adult individual.
That's right.
What kind of proceedings do you see there? Is it individuals who perhaps are turning 18 and have special needs versus adults, older adult seniors who might be suffering from cognitive change or decline?
It's all of the above. As you were saying, conservatorships are kind of the cousin of a guardianship, right? It's the same general concept, but it's for an adult instead of a minor. And in some states, adults with disabilities, their process is called a guardianship. We just happened in the state that I'm in to bifurcate this, to call minors need a guardian, adults with disabilities need a conservator. And again, it's this process where you take the decision making away from the individual and you vest it in someone who the court deems better able to make those decisions. And you might say, well, why would you ever need that? Well, a common reason would be you might have an individual who was born with an intellectual disability. So, Down syndrome, for example, or there are, many examples of this, where so long as they were under 18, the parent had the legal authority to make medical school decisions, life decisions for them. But then the moment they turned 18, suddenly the schools and the doctors are saying, well, we don't have to speak to you anymore.
Right.
We need a court-authorized conservator to be the one to legally make these decisions. So that would be one scenario. Another very common one is the age-related illnesses issue, right?
Dementia, Alzheimer's.
Yeah. There's someone who, that is a huge issue that people of my age are dealing with because they have aging parents who, for years and years and years were always capable of making their own legal decisions. Now, suddenly the decisions are not as clear anymore or in their best interest. Maybe these are vulnerable adults that are being taken advantage of by someone who comes in and doesn't have, their best interests at heart. And they're just such kind, wonderful people that they'll write a check to anybody who asks for it. In those situations where an older adult is being taken advantage of, or if they are losing their mental capacity to make good decisions for themselves, a conservator may need to be appointed to step in and make the decisions for them.
And that is, I think, a situation that a lot of listeners are facing, like you just said, aging parents. I have aging parents and making sure that they are appropriately taken care of. Do you ever see the person over whom a conservatorship is sought coming to court and fighting against that conservatorship?
Yes. And it's tragic, really, because if a person has diminished capacity, where they are vulnerable and where they are in need of a conservator, they also have a limited ability to understand the process and what's going on and why someone is seeking conservatorship. I cannot tell you how many times I've had folks come in here that believe wholeheartedly that they don't need a conservator, and they'll say, Judge, why is my daughter suing me? And it's heartbreaking because that's their perception is, they've been served with papers, and a judge might take away their right to make their own decisions and access their own money and, be fully independent humans. And there are times when they're not happy about it.
And it's scary.
Oh, it's terrifying to them.
Because if they can't understand what's happening and it's happening directly to them, that's a scary situation for the person who's at the center of the conservatorship.
It is. And realize that that person might be the center of a dispute among their children.
Right.
Let's say, mama's in here and child 1 is seeking to be the conservator. Child 2 and 3 are on her side, but children 4 and 5 don't think mom needs a conservator. So poor mom is caught in the middle of this mix, and overlaying all of this are sometimes very complicated issues, such as some of the children live in mama's house for free and don't pay rent, so they don't want that gravy train to end.
Right.
Or maybe they have legitimate disagreements about, whether mom can independently remain in her home.
And all of the adult children, they need to be served, right, with the petition for the conservatorship.
We do in our state. I can't speak to other states that might have different requirements, but our statute requires service of process to the person whose, rights are being in question. We also give notice to the closest next of kin to the extent that we can determine who they are. And then we also, the statute requires notice to the person having, quote, care and concern. So, for example, if there was a non-relative family member who's living in the home and, providing caregiver services or something, that person also gets notified so that they can all come to the table, have a voice as to what is in the best interest of this person. Because at the end of the day, we are required to seek out a solution that is the most limited restrictions as are necessary to protect the best interests of we call them the respondent is the legal word for it.
The respondent being the person over whom the conservatorship is sought.
The adult that's alleged to have disabilities.
Right. And we all know that our healthcare information is generally protected under HIPAA. How would you get access to a medical evaluation of somebody to help determine whether there is some incapacity or diminished capacity that would require, some formal assistance in the form of a conservatorship?
You know who I think you should have on your podcast to answer that question?
Who's that?
Physicians who see these patients. Because in my world, I see that after they have got the information from the doctors, how they get that information, I think, sometimes can travel different paths, right? Mm-hmm. Let's say you're the child who always goes with mom to those doctor's appointments. The doctors know you, they're familiar with you. It might even be the doctors that have initiated this conversation and expressed a concern and said, you might want to think about looking into this. And the doctors will sometimes be very forthcoming about filling out a report form and giving it to the caregiver child and saying, well, you can take this to court with you. Other times the doctors will not do it without, being served with a subpoena to sit for a deposition and, really kind of given the runaround because they are concerned about protecting the privacy interests of their patient. So it can fall kind of all over the spectrum. The good thing about it is we've got the statutory authority to order a medical evaluation to be done. So occasionally when the doctors won't provide the information to the patient, or the patient's representative or close family members, every once in a while we have to order that to be done.
Okay. So that would be a last resort.
Yeah. Then the doctor's protected because they're just simply complying with the court order. And there are some protections on our end as well. So if you have a sworn physician report that's filed in our public records, it goes under seal.
Okay.
So for example, if you were looking at a conservatorship file, the entire file would not be under seal at all because court records are open and transparent. But when they contain otherwise protected healthcare information, that is either placed under seal or it's redacted. Sometimes you have a document that'll have big black lines through certain portions of it. And what that means is when I look on my computer as the judge of the court, I can see what those words are that are blacked out, but the public cannot.
Okay.
So we do that for things like social security numbers, dates of birth, everything but the last, 4 digits of an account number for bank accounts. Things like that will automatically be either redacted or placed under seal.
Okay. Well, getting back to decedents' estates, because I know that's really most of what you handle in probate court, are you seeing any trends as to problems that are coming up or any difficulties that people are encountering with regards to probate estates?
Yeah, well, there are a lot of examples. And usually, and I'm going to just kind of be very simplistic at first, usually the problems occur because the surviving family members are surprised or disappointed by the outcome.
Okay.
So, for example, grandchild Johnny has been living in grandma's rental house all these years. Grandma told Johnny, oh, well, when I die, you're going to get the house. And lo and behold, she dies and there's no paperwork whatsoever that indicates he gets the house. Now Johnny's upset. Now, for the first time in his adult life, he's got to pay rent someplace. Mm-hmm. That causes problems and conflicts because the family members are not experiencing what they thought was going to happen.
So when you were practicing, would you encourage your clients to have conversations with their families about estate plans?
Yeah, I did to the extent of their comfort level. Mm-hmm. I would always tell clients, look, this is your private business. You don't have to share what you've done or what you're going to do with anybody. However, when you're dead, the rest of your family has to still live with each other.
Right.
Maybe not literally, but, like they're still family and they have to interact and their relationships are going to be affected by what you do.
Right.
So think about that. And if you choose to share with them some information, it might actually help them come to terms with your decisions. It might help them not fuss about it because they heard it straight from you.
Okay.
So as a general proposition, I think, sharing with the close family is a good idea. Maybe not every little minute detail, but even simple things like telling your 3 children, yes, I've done a will. Here's where I'm keeping the will. Here's the name of my lawyer.
And maybe don't tell your grandson they're going to get the house if you haven't done anything.
Right. And what I have seen happen on the back end is sometimes the person who's deceased told different people different things.
Oh, boy.
I remember a client who he had 3 daughters, all grown. They were spoiled daddy's girls. And he told all of them exactly what they wanted to hear. But he also told his new wife what she wanted to hear.
Okay.
And what she wanted to hear and what they wanted to hear was not the same thing. So he wants to be the hero and tell all of these women in his life that he loves what makes them happy. And lo and behold, when he died, they were not happy. And years of conflict and litigation, expensive litigation, resulted.
Perhaps because each of them is trying to, looking favorably on it, trying to honor their dad's or their deceased husband's wishes. Maybe not the circumstance you're talking about.
That is a half glass full view on it.
Yeah, it is. I'm just putting that out there.
My take on it, this particular family was that they hate each other a lot.
Okay.
Have a lot of resentment that has nothing to do with, the situation at hand. And they're all pretty selfish.
Okay. Yeah, I could see that would be more my practical experience would say that would be the type of situation we would encounter. Yeah.
But people will say all the time, well, I'm just trying to honor, as you said, I'm trying to honor their wishes. I'm trying to do what I think they would want done. But the best thing that you can do as a person who's going to die, because you're going to die, everybody's going to die, is to make your wishes clear, in writing, and up to date.
That's a really important point, making your wishes clear. What have you seen along the lines of AI wills or DIY wills? How are those turning out for families?
Well, not so good. AI, of course, is part of the world we live in. Internet documents, forms, documents are out there. And what I have seen in my time on the bench is that, well, let me contrast this. When I was a lawyer in private practice doing this for, 25 years, I didn't see a lot of homemade wills.
Right.
Because I was dealing with clients who were paying me to do their wills for them.
Okay.
So I think I was a little naive in understanding how prevalent that practice is. Now that I'm a judge and I'm seeing literally every will that comes through the door, a shocking number of them are either homemade, written out, by someone who just wrote some stuff.
You mean in their own handwriting?
Mm-hmm. Yeah. Or maybe typed themselves in more of a narrative form. Or in many cases, I'm seeing wills that were filled out using different forms that are available for free or low cost on the internet. Now, in theory, you would think, well, that's a great thing, right? That means everybody can have a will. But the problem with that is when you're filling out the form in a way that doesn't involve legal expertise, advice, understanding that precise words matter, and the order in which those words are used, the punctuation, there are lots of things about doing a will that the skill of a lawyer makes a big difference on how clear and understandable and complete it is. What I'm seeing in practice is that people are doing their own wills, and then that will might meet the requirements for admission to probate. Often they do, but then the secondary problem becomes, well, what's the will mean? Just sort of this mass confusion about their words on a paper, but we can't reconcile this sentence with that sentence. Or something was said in a way that there are multiple possible interpretations. And so on the back end, a lot of legal work that you pay lawyers to do gets done trying to resolve the question.
So, for example, you might say, I want my cousin Joe to use the proceeds from the sale of my house to educate the grandkids.
Mm-hmm.
What does that mean?
What does that mean? I don't know. That's the big question, right? Does that mean you want to create a trust? Does that mean you want all of the proceeds of the house? Is it all the grandchildren? Is it just those 2 grandchildren? Is it equally? Is it grandchildren that are born after the date you signed this will? I mean, these are nuances that matter. And you can imagine that depending on what side of the interpretation you fall on, you're looking at it through the lens of your own glasses.
Let's say that I'm writing a will today and I know I have a house, I have a bank account, and I've got a retirement account.
Mm-hmm.
And I give my house to Joe Smith. I give my bank account to Jane Smith. And I give my retirement account to Jenna Smith.
Yeah.
And I'm done. I covered it. What could go wrong? I was very clear.
Yeah. Well, then the question becomes, what about your car? What about your other bank accounts you didn't mention? What about the stock certificates that are still in the lockbox, or from your grandmother? It's very common that when people do their own wills, they forget to include a catch-all, which is called, in legal jargon, it's called a residuary clause. But it's basically one to say, and I leave everything else that I didn't mention previously to particular people in a particular manner. So you might have a will that gives away the first 3 things and then is silent as to everything else.
Right. I gave my house. What about the furniture in the house, the jewelry, that really expensive painting?
Yeah.
Did that go with it?
Maybe, maybe not. It really does depend on the precise words used. But hey, even worse, guess what? That house has a mortgage. There are credit card bills. There's an ambulance bill that needs to be paid. There's lawyer fees. There's taxes. There's the accountant's bill. If the will doesn't give us guidance about the source of how those things are going to get paid, then guess what? Everybody thinks that they get the property, but they also think they don't have to contribute anything to paying the bills.
Right.
Therein lies the conflict. Right?
Right.
Because the person who gets the house is going to say, well, I don't want to sell the house. It's not money, it's a house. So I shouldn't have to pay the bills. And the person that gets the $10,000 bank account is going to say, well, wait a minute. I only get a $10,000 bank account. You get a $400,000 house. You ought to pay the bills. And so a properly drawn will can make the rules, right? You can lay out the rules that have to be followed to fully administer the estate. And if you fail to do that, then you either have to look at the default rules of your state, or you have to ask a judge to tell you what the rules are, or to tell you how to interpret this particular document that was maybe not written in such a clear way or complete way.
So if I write a will that is not clear, by whatever means, whether I did it myself or maybe I did it with an attorney who really didn't do estate planning, maybe just sort of was doing a one-off for a will. Do you think that it ends up being more expensive to correct a will after someone's died versus do it properly on the front end?
There is no question about that. It is so much more expensive to do the cleanup work on the back end than it is to just do the document properly in the first place. And you know why? Part of the reason is the whole point in construing a will is to try to figure out what was the deceased person intending to be done. What was their desire? What was their intention? And if that person is alive and the lawyer is having a conversation with them, they can ask questions of the person to figure out what is their intention so that they can write up the will in the way that carries out that intention. If you are trying to clean up the problem after the fact, guess what? That person's dead. So you can't ask her anymore. So it becomes so much harder to figure out that intention when your star witness, the one person who could answer the question definitively, is not able to answer the question.
Now, if somebody is confused about what probate court is and what goes on there, is just any old person allowed to attend a probate court hearing and see what it's all about?
In large part, yeah. I mean, courts are open to the public, and any just citizen or any person, unless there's some court order saying you're not allowed to be there, you can go to the courthouse. You can usually find information online about what cases are set on what days and what courtrooms. But you can go to the courthouse and you can just sit on the bench and you can watch.
Is there a dress code in Davidson County probate court?
That is a good question. And I'm gonna say, I think we have an official dress code, but I am quite lenient.
Okay.
In my court. And I'll tell you why. We have people that come from all walks of life. Some that, could barely come up with the $2 to buy the bus ticket to come that day. And it's a struggle for them. My view on it is if they need to come in and their Sunday best is a pair of blue jeans and a t-shirt, I'm okay with that.
Yeah.
I think it's more important for them to have access to the court and education and understand what's going on in their case than it is to necessarily be part of a fashion show. So I'm pretty lenient. As long as people aren't wearing anything that's distracted or offensive or, that kind of thing, I just kind of say, come as you are. Now, the lawyers will be dressed a different way.
Right.
The lawyers really need to look nice and professional. And, often they'll have a jacket on. Usually the men do have a jacket and the women often do as well. So it's usually pretty easy to spot the lawyers. But, people who are coming to court, I don't think, in my view anyway, you have to feel excluded because you don't have, fancy clothing or something like that. My court officer will ask, gentlemen that are wearing hats, he'll say, could you take your hat off, please? Or, that kind of thing.
Okay. That's good to know because I think that people could learn a lot by just attending court. And I brought my daughter to court. I brought your mom to your court. And I think I know it was a very educational experience for my daughter.
Yeah. I did want to point out that some courts, not all, but many courts will be conducting hearings both in person and by Zoom. So, for example, whenever I'm in the courtroom conducting a hearing, we have our Zoom link on. So we have some folks that just simply watch the Zoom link without actually showing their video and, having their sound on. They just watch and observe. So, think about this. We may have a decedent's estate that has one lawyer involved, but 20 different beneficiaries. Do we really need 20 people to come to court every time? No. But it is not a problem for them just to log on to Zoom and watch what happens so that instead of, being in the dark about what's going on with their case, they can see in real time what the lawyer's saying, what I'm saying, and what the outcome is. So people do that as well. But not all courtrooms have Zoom or will let you just freely watch from the Zoom, but we do.
Judge Hedrick, thank you so much for taking the time to join me today. This conversation was very helpful.
Thank you so much, Jill. It was fun to do this today, and it's good seeing you. It's been a while, so good to see you again.
Good to see you too. If you have a parent who might be inclined to go the DIY or internet will route, and today's conversation has you thinking that might not be the best option, my parent prep plan can help. I'll walk with your parents through the estate planning process, work alongside the attorney, and keep things moving so you don't have to. You'll find the details linked in the show notes and at deathreadiness.com/parentprepplan. And if you found this episode helpful, I'd love for you to share it with someone you think could benefit from it. This is Death Readiness, real, messy, and yours to own. I'm Jill Mastriani, and I'm here to help you sort through it, especially when you don't know where to start.
Hi, I'm April, Jill's daughter. Thanks for listening to the Death Readiness Podcast. While my mom is an attorney, she's not your attorney. The Death Readiness Podcast is for educational and entertainment purposes only. It does not provide legal advice. For legal guidance tailored to your unique situation, consult with a licensed attorney in your state. To learn more about the services my mom offers, visit deathreadiness.com.